It's your boy, Legal Doc Guy, ready to put on a new episode today for question 4 of the 2012 California bar exam. Let's fade out here. I don't know why I did that. I just thought it'd be fun to do that. Anyway, so today we're going to be working on question 4 of the 2012 California bar exam. July. We are in July, guys. So this is question 4. This is essentially a contracts question dealing with employment contract and land sales contract. It's kind of like a double thing here. Can you guys see me on the screen? Yeah, that's me. So I don't know how many days we got. I know it's under 80 because I haven't done a few videos. I could probably find out real quick. Let's see. Put this on here. New chit chat. I'm just going to put how many days until the bar exam. Let's see what it says. February 26th, California bar exam is held February 24th and 25th. Today is December 11th. That is true. Let's calculate it. 74 days. Holy smokes. We went from 82, 83 days all the way down to 74 days. So you guys, no joke. The bar exam's right around the corner. It's Christmas time. Everybody's getting ready, gearing up, buying presents and all this stuff. And I'll admit, I got myself stuck in it too. You know, everybody's needy, but this is the time where we got to start busting through all these questions, doing as many MBEs as we can, get stuff. I used to mess with these cards that I bought online one time, and you know, there's thousands of them for every subject, and it's basically the black letter law. It is the black letter law, but who's got time for that? I sure don't. So I'm trying to condense this thing where I'm doing questions, bar exam questions for this podcast, and then trying to hit as many multiple choice questions, MBEs, as I can. Trying to do rule statements because one of the things on the bar is you got to know some of the rules. And so what I've been doing, and I said this on the last show, but obviously, you know, for you new people who haven't seen the show yet, I like to put rule statements on here. It depends on what subject I'm doing. I have some for personal jurisdiction and, you know, civil procedure stuff. And then these two right here are witness testimony for a criminal case, which is really just an evidence question, but it presented itself like it was a criminal murder trial thing. That was in one of the last episodes, which I'm going to do again because I just bought me a new XLR cable because I was going in and out as I was talking. The first time, I just forgot to put the mic to my mouth. The second time, I kept coming in and out. Something was going on, and I believe it was the XLR cable. Maybe it was just bad, and so I bought me a new one. I invested this for you, and so hopefully it works, and hopefully that that I'm not cutting in and out, because then it just sounds choppy and you don't know what I'm saying, because then all of a sudden I'm talking and I'm just going, and then I come back in and out, and you know, it sounds like that. So who wants to hear all that? Who wants to listen to somebody talking when that, and then they can't even hear? All right. So let's get to it. Let's hop to this bad boy. So this is what we're going to be working on today. We're going to be working on question 4. And as I said, this is a contracts question. And as usual, we're going to start with the call to question. What rights does Peter have and what remedies might he obtain as to employment and the parcel of land? So the cool thing about the call of the question, it's always going to tell you what it wants you to answer. So we got to answer the employment aspect of this fact pattern, and there's a parcel of land. So we know right off the bat there's an employment issue and there's a parcel of land issue. We don't really know anything other than that, but we know there's two things we're going to be talking about. Okay. And at this point, we don't even know that we're in contracts yet. We don't even know that we're in contracts. Okay. It just says employment and parcel of land. But the more practice you get with these, you'll start to, this is a contracts question. Okay. So starting at the top, Peter responded to an advertisement placed by Della, a dentist, seeking a dental hygienist. Okay, so far so good. Nothing really there. We just know that Della put out an advertisement. After an interview, Della offered Peter the job and said she would either, 1, pay him 50 G's per year, or 2, pay him 40 G's per year, and agreed to convey to him a parcel of land worth about 50 G's if he would agree to work for her for 3 consecutive years. Okay, so we got an option here to either take a $50,000 a year salary, or to take a $40,000 a year salary with the promise of conveying a piece of land. Okay, so Peter, he accepted the offer and said, I'd like to go with the second option, but I would like a commitment for an additional 3 years after the first 3. Okay, I don't know why he wants to work more years, but I mean, kind of tying himself down there, but that's what he wants to do. He wants to materially change the contract from duration from 3 years to 6 years. Okay, fair enough. And Della said, good, I'd like you to start next week, big boy. So that's what he's going to do. He goes to work. After Peter started work, Della handed him a letter she had signed, which stated only that he had agreed to work as a dental hygienist at a salary of 40 G's per year. Bitch, dude, what is she doing? Why would I would have called her on that right away? I would have been like, look, girl, you said that you were going to give me a parcel of land, but there is nothing in this writing that's saying there's a parcel of land in here. So you could already see the issue, one of the issues popping up right here. After Peter had worked for 2 years and 9 months, Della decided that she would sell the parcel of land and not convey it to him. Messed up. Even though she had always been satisfied with his work, she was satisfied. She fired him. What a bitch. She fired him. What rights does Peter have, and what remedies might he obtain as to employment and the parcel of land? So what we got here is some contract issues. Okay? So the first thing when you're in a contracts question is you got to ask yourself, what law governs? If you went to law school, you already know we have to decide which code, which law or body of law is going to govern an employment contract. And especially in a clause or a condition of land transfer. Okay? If you're a first-year law student, you may not pick up on that right away, but that's what's cracking right here. We have to decide what body of law is going to govern this particular contract. So as you know, UCC governs all contracts relating to the sale of goods. Okay? So we know this is not a sale of goods. This is for an employment contract and involves a transfer of a parcel of land. Neither one of those are goods. So the UCC will not govern this. So it will be governed by the common law. Now, so your first heading is going to be governing law. You just put it up there and you underline it, put it in bold letters, governing law. And you're going to let the reader know that because this is an employment contract and not for the sale of goods, this contract will be governed under common law principles. And that's it. That's all you got to do. I don't even need to look at my notes for that one. I mean, that's just it right there. So obviously common law contracts, questions involve employment. Questions involving contracts relating to employment and a promise to convey land are governed under the common law. Okay. So then you're going to have a next heading. Okay. And your next heading is going to be about contract formation. Okay. So as you know, in order to have a contract, you need an offer, acceptance, consideration, and the statute of frauds must be satisfied in order to have a valid contract. Okay. Now, some people differ as to whether or not statute of frauds, you need that in order to form a contract, meaning that you would just need an offer, acceptance, and consideration. And that statute of frauds is kind of, its own section on its own. But I think that for contracts questions, the statute of frauds should always be part of the formation. Okay. But some people do it different. So we could obviously do it apart. A lot of people do that, and that's perfectly fine. So then that means in section 2, contract formation, we're just going to deal with offer, acceptance, and consideration. So an offer, there's many different ways to define offer, but they all sound the same. Okay. The way I like to define it, and which is the way that I learned it in law school, is that an offer is an outward manifestation of present contractual intent, certain and definite in its terms, made to the offeree and has not been terminated, is one way that you could define offer. Another way to define offer is just that it's an offer. An offer is a manifestation of present intent to enter a bargain communicated to the offeree and creating a reasonable expectation that the offeree can accept and form a contract. Either one is good. They both work. Okay. So obviously here we have to make sure that we recognize what is an offer, what is a counteroffer, and what is an acceptance. Della, who's a dentist, she advertised for a hygienist. And after interviewing Peter, she offered him a job on either of two terms, either the $50,000 or the $40,000 a year, and a promise to convey a parcel of land, supposedly worth $50,000. But even though she's never in the fact pattern, she doesn't say, Green Acre, or she doesn't identify the land. Okay. But we do know that she gave, what was his name? Peter. She gave Peter two options for employment: either the $40,000 per year with the conveyance of a parcel of land worth 50 G's, or just 50 G's a year. And my man went with option 2, $40,000 a year plus the conveyance of the land. But the offer was still made. She offered those. She made an offer for employment, and he could pick from either one of the two. So you would just say heading offer, and you define offer, and then you would just say something like Della, and she's a what? Dentist? Della, a dentist, advertised for a hygienist, and after interviewing Peter, offered him a job on either of two terms, $50,000 a year or $40,000 a year plus the promise of a parcel of land worth $50,000. If he agreed, and we have to include that, if he agreed to work for 3 consecutive years. So this is a valid offer with 2 alternative packages. It's still a valid offer, even though it's still certain and definite in its terms, because he can identify one or the other. He could pick A or he could pick B, 1 or 2. Okay, so there is an offer, a valid offer. All right, and then we put a new heading, Peter's response, which is either an acceptance or it's a counteroffer. So we can think about the mirror image rule and a counteroffer. So you'll see here in the fact pattern, if you can see my cursor, he says Peter accepted the offer. So at first glance, we have an acceptance. I'd like to go with the second option. So he picks number 2. That's an acceptance. If that's where he stopped talking, that would be a valid acceptance. But he says, but I would like to commit for an additional 3 years after the first 3. Okay. So those are words that are not a mirror image of what was said before. Now, I have a rule that I like to use for what an acceptance is. And an acceptance is an unequivocal acceptance of the terms of the offer. Okay. It's not a complicated, for me, it's not a complicated definition or, rule, but I think it works. It's just an unequivocal assent to the terms of the offer. Okay. And, it has to be mirrored. The terms have to mirror one another. So any material change is deemed a rejection and then constitutes a counteroffer. So a mere request or suggestion that does not, condition assent is not a counteroffer. Okay. So here, like I said, Peter said, I'd like to go with the second option, but I would like to commit for an additional 3 years after the first 3. So he changed the terms. So we're going to call that a counteroffer. So this adds a material term, total of 6 years instead of 3, which changes the duration of employment. So this is a significant term in an employment contract because you're going from 3 years to 6 years. Okay. And a reasonable offeror would regard this as more than a mere request. I mean, he is basically conditioning his language. I'd like to go with the second, but I would like a commitment for an additional 3 years. So he's telling her, I need a commitment. Like, basically, I'm not going to take this job unless you give me an additional 3 years after the first 3. Okay. So most likely Peter's statement is a counteroffer for the $40,000 a year plus the land after 3 consecutive years. Because he's not saying I want to work 3 more years to get the land. He still wants the land after 3 years, but he's just saying that he wants a 6-year commitment from her. But he still wants the land after 3 years, right? Because it wouldn't make sense if he was like, oh, I want to work an extra 3 years to get the land. That's not what he's done here. So anyway, so then we have to go to consideration. Okay. Well, actually, let's go to her acceptance. So that was a counteroffer. Now we have an acceptance by Della because she says, good, I'd like you to start next week. So like I said, an acceptance is a manifestation of assent to the terms of the offer, and it's made in a manner invited or required by the offerer. So she has to accept, according to the terms of the offer. And of course she responded, good, I'd like you to start next week. So that's assent, right? So this is an unqualified assent to Peter's proposed package. She doesn't reject the added 3-year commitment. Instead, she enthusiastically agrees and sets a start date. Thus, Della accepted Peter's counteroffer, forming a contract for 6 years. Employment for $40,000 a year plus conveyance of the land upon 3 consecutive years of work. So there's also a valid consideration, which I would probably just hit this real quick, because Peter promises to work and accept a lower salary initially, $40,000 instead of $50,000 a year, in exchange for the land and longer commitment from Della. So there is a consideration, and consideration is just basically there's a bargain, there's a detriment, a benefit and a detriment to both parties, right? He's got to work, she's got to give it the land. He gets the land, she gets work from him. It's a bargain for, it's a benefit and a detriment to both parties. Okay, so we can conclude then that we do have a valid employment contract. And of course, he went to work and he worked for 2.75 years, just shy of the 3-year mark. She pulled a fast one on him. And of course, we know that there's no terms relating to the parcel of land. It just says that he agreed to work for $40,000 a year. It's pretty shady what she did there, but so anyway, so what we've done so far in this on our paper when we're taking a bar exam is we first determine what the governing law is with a heading saying governing law, and then in section 2, formation of the contract, we have offer, acceptance, and consideration. In there we have counteroffer, so they kind of threw that in there, see if they wanted to know if you're going to recognize that. Most people do, sometimes people don't, but there was an offer. There was a counteroffer, and then an acceptance, and then we went through very quickly that there was and declared that there was consideration was valid. Okay, so then the next section 3, we can just call it section 3 because it's the third main area, is going to be the Statute of Frauds. Okay, so Statute of Frauds just basically means, and you should probably let the reader know this, that certain contracts have to be in writing and signed by the party to be charged. Okay, so a solid rule would be something like, under the Statute of Frauds, certain contracts must be in writing and signed by the party to be charged, and including a contract that by its terms cannot be performed in 1 year from formation. Okay, so that's a rule that I would put for our first issue, which is the 1 year provision for statute of frauds. So under the statute of frauds, contracts that cannot be performed within 1 year must be in writing. Okay, signed by the party to be charged. So we do see here, after Peter started work, Della handed him a letter she had signed, which stated only that he had agreed to work as a dental hygienist for $40,000 a year. Okay, per year. So the agreement requires Peter to work for 3 consecutive years to earn the land plus 3 additional years. Neither the 3-year nor the 6-year employment contract can be fully performed within 1 year. So that means that there needs to be a writing. So both the 3-year commitment and the additional 3-year commitment fall within the 1 year provision. So we just need to let the reader know in the statute of frauds, under statute of frauds, that there's a 1 year, that contracts that cannot be performed in 1 year require writing. So there's basically a 1 year provision. Okay. And then we're going to go on to part 2 because we have to deal with the land. So the land contract provision of the contract. So there's this 3-year and 6-year provision that's supposed to be in the contract. And then, I mean, obviously there's no, we haven't talked about whether or not the writing is sufficient. We're just letting the reader know that a writing is required. That's all we've really done. Okay. We haven't really given a full analysis yet because we wanted to also include the land contract provision. And we can break it up or put it all together. But I'm just going to break it up. So part B of the statute of frauds would be the land contract provision of the contract. And the rule is that the contract for the sale or conveyance of an interest in land must also be in a signed writing, stating the essential terms like the parties, the property, the price, the consideration. So as you know, in real property, from what we know from real property, is that whenever you're transferring land, it has to have all the, I forgot what they call that actually. When you have all, I think there's 5 of them. You know, the parties, the price term, you know, you have to have the identifying information. There has to be adequate consideration, things like that. Whenever you're transferring land, you can't just put in the contract, he's buying Green Acre, but there's no price term, right? It's not like in the UCC where if you say, yeah, I'm going to buy, 100 widgets at market value, where the court can come in and they can, through evidence, determine what is the market value of those widgets. This is a piece of land. So it has to be certain and definite in its terms, meaning you have to identify the property. You have to identify who the parties are. You got to identify what the price is. I think there's 2 other things you need to also include in that. But for the most part, as long as you need to have the parties, you need to identify the land, and you got to have the price. It's like, what are you buying it for in order for that to be a valid contract? Okay. So anyway, Della, she promised to convey a parcel of land. We know that. And she said that it was worth about $50,000. And she offered that to him in exchange for Peter working for 3 years. That is a contract to convey land and is within the statute. So that's what we need to let the reader know, that they entered into this agreement that he was going to work for 3 years and that she was going to convey a piece of land for that was worth $50,000 to him once he completed the 3 years. So we're just letting the reader know, hey, this type of contract, this provision is governed, falls under the statute of frauds, which means that this contract or this provision of the contract requires a writing. Okay. Now, if the agreement that he was going to work for less than 1 year to get the land, then it may not fall under the 1 year provision requiring a writing, because it's more than 1 year. Because if it's less than 1 year, if she said, if you work for me for 6 months, I'll give you the land. Well, it wouldn't require a writing under the 1 year provision because it's under 1 year. But because it's for a parcel of land, it does require a writing. So there could be multiple reasons why a contract would fall under the statute of frauds. In our case here, it falls under the statute of frauds because it's for a contract that will take longer than 1 year. And it also falls under the statute of frauds because we're talking about the conveyance of a piece of land. So we just need to let the reader know that we understand that it falls under the statute of frauds for two separate reasons. One, because it's a contract for more than 1 year that would take longer than 1 year to accomplish. And because it relates to the conveyance of a piece of real property, a parcel of land, which also requires a writing. So next we're going to, talk about the sufficiency of the writing. So, obviously after Peter started work, Della only gave him a signed letter it only stated that he had agreed to work as a hygienist at a salary of $40,000 a year. That's what we got. That's all she put. It's just this one sentence right here. So obviously that ain't going to work. So we need to understand that a writing satisfies the statute of frauds if it is obviously has to be signed by the party to be charged. So it says here that she signed it right here. Oh, what happened to my big arrow? Anyway, she signed it right here. Okay. And, it has to reasonably identify the subject matter. All we really know is that it's a parcel of land, but it's not in there. It's not in the writing. There's nothing about it in the writing. Okay. It states the essential terms. So the nature of the contract, the parties, the material terms like quantity, duration, or price. Nothing in the writing that she gave him that had any of those terms in it. And fourth, and lastly, it reflects that the contract has been made. He didn't sign it. I mean, she signed it. But all it talks about is just that he agrees to work as a hygienist for a salary of $40,000. And that's it. So the letter is signed by her. And it does identify Peter as a hygienist for 40 G's a year. However, it doesn't mention the 3 year or the 6 year duration or any promise to convey a parcel of land. So it falls under two areas. It falls under the 1 year duration, and it also falls under the parcel of land. But it doesn't mention either one. It doesn't mention the 3 years. It doesn't mention the 6 years, and it doesn't mention a promise to convey any land. Thus, the writing arguably satisfies only an indefinite employment contract at $40,000 a year. So basically, the writing is only sufficient to show that there's an at-will employment contract, and it's not clear in the terms. So he's trying to sue for this parcel of land, and he's trying to sue because she fired him before the 6 years was up. However, this writing does not satisfy the statute of frauds. Right? It doesn't satisfy the multi-year employment commitment, and it doesn't satisfy the land conveyance because the land's not even referenced. Okay? So we have now, under the statute of frauds, have identified two things. One, that this contract falls within the statute of frauds, and two, that, first, one, we identified that this contract falls within the statute of frauds under one, the 1 year provision, and two, the parcel land conveyance provision, right? Now, the second thing we've let the reader know is that this writing does not satisfy those two provisions under the statute of frauds. So we've identified that it does fall into the statute of frauds, and then we identified that it does not satisfy the statute of frauds. Okay? So now we could have a new section, or we can just go continue on in our analysis, whether or not there's any exceptions to the statute of frauds. Okay. So there is an exception that you can use for either the 1 year provision and for the land contract. Okay. Now it's really difficult to figure these out if you don't have experience in this. It's very difficult to come up with the exception because we're gonna see that it doesn't apply. But that's the exception that you have to argue. You have to argue the rule against these facts. So starting with the 1 year provision, we're going to use the exception to the statute of frauds of the part performance. So the rule under this 1 year provision, the modern rule is that full performance by one party may remove the contract from the statute of frauds. Partial performance is not sufficient. Okay. So it has to be full performance. Now I know that the exception is called part performance, but in reality, the rule is that under the 1 year provision, the rule is that, or at least the modern rule is that full performance by one party may remove the contract from the statute of frauds. Okay. Now ask yourself, did he perform fully under this contract, even if it was for 3 years? Well, no, because it says here after Peter had worked for 2 years and 9 months, or in other words, 2.75 or something like that, 2.75 years, Della decided that she would sell the parcel of land and not convey it to him. And even though she had always been satisfied with his work, she fired him. So he did not fully perform because he got fired just before, 3 months before he was about to fully comply with that 3 years. So he did not fully comply with the 1 year provision. Okay, so we know what we know is, I'll repeat myself, Peter worked for 2 years, 9 months, not the full 3 or 6 years. So accordingly, he has not fully performed. So the 1 year provision remains a bar to enforcing the multi-year term. So he cannot enforce the multi-year term because he hasn't fully performed. So part performance will not work. So that's that. Part 2 is part performance relating to the land contracts. Now, if you know about land contracts, it has a rule about whether or not you've partly performed under a land sale contract. So for land contracts, part performance may serve as an exception when the buyer, we have a 3-pronged test here, takes possession, makes substantial improvements, and pays all or part of the price. So you know from your land sales contract class, which is probably contracts 2 if you're in law school, that under part performance relating to land sale contracts, that a lot of times in the fact pattern, the buyer will take possession of the land and then he'll make some kind of substantial improvements on that land. And he'll even pay part or all of the purchase price. But for whatever reason, the owner does not want to convey the land to the buyer. A lot of situations like that. However, here, as you know, he never takes possession of the land. He never took possession of the land or made improvements or paid any of the purchase price. He only performed services as an employee, and he could not have done that because she doesn't even, in the fact pattern, doesn't even identify what the land is. She doesn't say, I'll give you green acre. She doesn't say that it's my parcel land with a number, like my parcel number 5 of my 25 lot parcels of land. She doesn't say anything. She doesn't write nothing. She doesn't say anything. She doesn't identify it. There's no price term, and he does not ever go on the land or make improvements. He never did any of that. So that is insufficient to meet the traditional land part performance doctrine. So the land conveyance is still within the statute of frauds and not supported by an adequate writing or the traditional part performance exception. He's crap out of luck as far as an exception to the statute of frauds of part performance. So that being the case, that he does not have part performance for the 1 year provision because he was stopped short, just shy of 3 years. So he never actually fully completed the contract, the work. It's funny how it works that way, but he didn't. And then with the land, he never took possession of it or made substantial improvements or paid anything towards it because he never went on the property. The facts don't tell us that she ever identified where that property was. So neither one of those, he's not going to be able to get around the statute of frauds by either of those ways. So what he's going to have to do is possibly a workaround of the statute of frauds by way of promissory estoppel. Now, promissory estoppel is kind of a tricky concept. When I was in law school, I understood it very well. And, as the years go by, you kind of just, what it kind of is, and then you just kind of forget. It has to do with, promise, that a promise was made and promise wasn't kept, right? So the rule for a promissory estoppel, all right, so even where the statute of frauds is not satisfied, a promise may be enforced if, now it's going to be a 4-prong if, the promisor makes a clear and definite promise, okay? The promisor should reasonably expect reliance. The promisee does, in fact, rely to his detriment. And injustice can be avoided only by enforcing the promise. Okay? So many courts allow promissory estoppel to override the statute of frauds to some extent. It's often limited to reliance damages, sometimes expectation damages. But it's sort of a workaround. I wouldn't call it an exception. It's more like it's getting around the statute of frauds as opposed to being an exception to the statute of frauds. Now, let's think about this. So, prong number 1, Della clearly promised Peter a parcel of land if he worked for 3 years. As you can see, she says, if you would agree to work for 3 consecutive years, I agree to convey him a parcel of land worth about $50,000 if he would agree to work for her for 3 consecutive years. That's a clear promise. She promised that clearly to Peter. And she was pretty clear about it being a parcel of land worth $50,000. Okay. If he would work for 3 years. So that's pretty clear that was a promise. Now, was it foreseeable he would, was it foreseeable that he would choose a lower salary and remain in a job in reliance on that promise? Well, yeah, it's foreseeable because that was one of the options she gave. She gave him an option of $40,000 a year and would agree to convey a parcel of land worth about $50,000 if he agreed to work for 3 years. And he accepted that offer. And his only counteroffer was that, instead of 3 years, that he could work for 6. And then she said, good, I'd like you to start next week. So it was foreseeable he would choose the lower salary and remain in the job in reliance on that promise, right? I think it was reasonable that he would rely on that promise. And I think he did rely on that promise that she would give him a parcel of land worth $50,000. Right. Now, the third prong, the promisee does in fact rely to his detriment. Well, he did rely. He worked for almost 3 years at $40,000 instead of taking $50,000. Or possibly another job. Like, obviously the market rate for his position was $50,000 a year. Right. But he worked for only $40,000 a year. Because he was expecting to get this piece of land here. So obviously he did in fact rely. And injustice, the last one, injustice can be avoided only by enforcing the promise. Well, if the promise is not enforced at all, Peter unjustly loses the benefit of his reliance because he will have worked for below market value of what his position as a dental hygienist is. His position is worth $50,000, like I said, and he only worked for 40. So if they didn't give him the land or the equivalent value of that land, he would lose out. So the court might invoke promissory estoppel to award some type of relief despite the statute of frauds. Particularly with respect to the value of what Peter gave up, which is he gave up $10,000 per year in the difference that he sacrificed in expecting that he was going to get that land, right? So that's basically all we would need to let them know as far as promissory estoppel. We just go through that 4-prong test for promissory estoppel. I think that he'll get around the statute of frauds, even though he didn't have an exception to the statute of frauds. I think he can still get around it by promissory estoppel. Okay. Now, this would normally be, where I would probably end my analysis. I probably run out of time. But there are more issues here. A new section would be employment rights and remedies, right? Because this has to do with employment. So was there a term employment contract? So if the statute of frauds is strictly applied, the multi-year duration is not enforceable because it is not an assigned writing. So the majority approach, the writing supports at most a contract for employment at $40,000 a year with no indefinite duration. So as I said before, that would basically just create an at-will employment contract, which is no contract at all. It is because you're agreeing to work and they're agreeing to pay you. But the duration part is not, there is no duration component. It's an at-will contract. They can fire you without cause at any time. So under the default rules, absent some type of specified term, employment is generally going to be at will, meaning that either party can terminate at any time for any non-illegal reason. Okay, so thus, as to the term of employment, Peter likely cannot enforce a 3 or 6 year fixed employment term due to the statute of frauds. I know it sounds messed up because she did say, if you work for me for 3 years, but he doesn't have an exception through the statute of frauds. So under an at-will employment relationship, she can fire him at any time, even unfairly, as long as there's no separate wrongful termination claim, like a public policy, which isn't raised here, but she hasn't violated any type of, right to employment or anything like that, or I don't know, sexual discrimination or something like that, right? None of that is here. So the conclusion as far as employment duration, just like how long he can work, or if he was entitled to work longer, Peter probably has no enforceable right to continued employment beyond the date that Della fired him, because the term employment agreement is barred by the statute of frauds, as I said, and the signed writing reflects only an indefinite employment. It's just it literally just says, after Peter started work, Della handed him a letter she had signed, which stated only that he had agreed to work as a dental hygienist at a salary of $40,000 per year. That's all that's in the writing. So how do you enforce something that's not in the writing, especially if you don't have a valid exception for the statute of frauds? Because remember, there's a 1 year. He's saying it was longer than 1 year. Well, that requires a writing. And he's also saying that she promised me a piece of land. Well, conveyances of land or any type of transfer in land or contracts having to do with the sale of land have required to be in writing. And it wasn't, regardless of what she said, right? So pretty messed up, right? But that's the conclusion. The conclusion is screwed up and he's not going to get that parcel of land. But I think he would likely get some kind of money, which I'll discuss in a second. But first, let's deal with the wrongful discharge and the lost future wages. Okay, so we'll deal with it right now. So that's basically what we're going to deal with right now. So the rule is that if a term of employment contract exists and the employer breaches by firing the employee without cause before the term ends, the employee can recover what we call expectation damages, equal to the wages for the remainder of the term, reduced by what the employee earned or could reasonably have earned in mitigation. Okay. So if the court somehow found that the 3 year or 6 year term was enforceable, by maybe treating the letter as evidence of a broader contract or applying estoppel to the 1 year provision, Della's termination at 2 years, 9 months would constitute a breach, right? Peter would then be entitled to wages for the remaining 3 months of the initial 3-year term. So not that you're going to go all in depth into this in your actual bar answer, but if you had the time, you could just jot down bullet point that the annual salary was $40,000. So you would take the monthly salary. So the monthly salary would equal $40,000 divided by 12, which would give you something like 3,333.33, right? And then, so you just let them know, and then you just times that by 3 months. Or another way you can do it is, 3 months equal to 10,000, is $10,000 in lost wages subject to mitigation. But under the more likely under the statute of frauds analysis, that term is not enforceable. And so Peter cannot recover lost future wages just as a matter of contract. So the conclusion, the primary outcome would be that Peter will likely not be able to recover future employment wages beyond the date of termination because the multi-year term is unenforceable and the default at will rule allows termination. You see, because the contract was for more than 1 year, had to be in writing, and because it wasn't in writing, then it reverts back to the at will rules, meaning what happens under at will. Well, if you know this, if you have a job, a regular job, wherever you are, your boss can fire you at any time. I can't turn and say to my boss, like if I got fired tomorrow, I couldn't go to my boss and be, hey man, Christmas, the end of the year is right around the corner. Like, you owe me for the 2 years leading up to January 1st. Well, no, because I'm an at-will employee. He can fire me for any reason. My boss could have fired me 100 times already if he wanted to. It does not matter. He could fire me for any reason. Okay, so moving on to the next section would be rights and remedies regarding the parcel of land. Okay, if there even is a parcel of land. Is there a contractual right to the land? Expectation. Like, he had an expectation that he was going to get a piece of land. So if the land promise were enforceable as a contract, Della's duty was to convey the parcel after Peter worked for 3 consecutive years. But there's conditions and there was prevention of that, of fulfilling those conditions. So we could have a heading that says conditions and the prevention doctrine or something like that. All right. And we'd come up with a rule where the performance of one party is a condition precedent to the duty of the other. So here that would be Peter working for 3 years. That would be the condition precedent to the conveyance. So the promisor may not wrongfully prevent occurrence of the condition. So if she does, the condition is excused and the other party can recover as though the condition occurred. So as you know, Peter had worked for 2 years and 9 months, very close to the 3-year mark. But Della, being a douche, fired him without cause, even though she was satisfied with his work. She liked his work, but she fired him anyway without cause. So she doesn't have cause. Okay. And Della's firing him, preventing him from completing the 3 years. So if the contract is enforceable, notwithstanding the statute of frauds, then Della's firing Peter wrongfully prevented the condition from occurring. She prevented him from completing those 3 years. So the condition, the full 3 years, is excused. And Peter is treated as if he had satisfied it, which I think is pretty fair. So Della's refusal to convey the land is a breach to her duty to convey. So the expectation remedy or contract theory, the rule is expectation damages put the injured party in a position he would have been in had the contract been performed. So think about that. Expectation damages put the injured party in a position he would have been in had the contract been performed. So where would he be? He'd be $50,000. He would have a $50,000 piece of land. Well, I don't think he'd be able to get specific performance. Peter was to receive, so we know that he was to receive that piece of land for $50,000 as compensation for working for 3 years at a lower salary. So if specific performance was available and and the parcel of land was identifiable, he could seek specific performance, which is conveyance of the land to him. Because the land is considered unique and monetary damages are often inadequate if the land is unique, right? But if specific performance is impossible, remember the facts tell us here that Della decided that she would sell the parcel of land and not convey it to him. So we can make an inference that she sold it. So that would mean specific performance is impossible, assuming that she sold it to a bona fide purchaser, of course. But if that's the case, then Peter can seek monetary damages equal to the land's fair market value at the time of the breach. So we know the facts only tell us that it was worth $50,000 or about $50,000. That's based on the facts. However, this entire expectation analysis is subject to the statute of frauds, which, as discussed, is not satisfied for the land contract, which is a bummer. So the statute of frauds barrier to the land conveyance. So we'd have to look at promissory estoppel. Because the land contract is not in a sufficient writing and no traditional land part performance exists. Remember, he didn't make substantial improvements or move on the land or anything like that. He didn't pay anything towards the land. So Peter must rely on promissory estoppel. So the application of promissory estoppel. So looking at that, there's obviously a clear promise. Della clearly promised the land after 3 years of work at $40,000. It was foreseeable that he would rely on it. Remember, we talked about that. It was highly foreseeable that Peter would rely on that promise in choosing the lower salary and staying with her as opposed to working somewhere else, right? And then actual reliance, because he did actually rely because he worked. He chose the lower pay and he stayed there for nearly 3 years. And there is an injustice where if they deny him any recovery for having worked for nearly 3 years at $40,000 instead of $50,000, he would be losing a benefit of the bargain. And so I think the court would apply promissory estoppel, and they could either grant expectation-like relief, like value of the land, or they could be more cautious and grant reliance damages, compensating Peter for the detriment he suffered in reliance on the promise. So the likely measure of recovery under promissory estoppel or restitution, or like a restitution based on a salary differential, he gave up. So just to go over that again, he gave up $50,000 a year and accepted $40,000 a year in exchange for the land. The difference is $10,000 per year. And we know from the facts that he worked 2 years and 9 months, or you can call that 2.75 years. So the total salary differential he sacrificed would be 10,000 times 2.75, which would equal 27,500. And so under promissory estoppel, and sometimes you could even argue this under quantum merit or unjust enrichment. Peter can argue that Della was unjustly enriched by saving $10,000 per year on his salary while inducing him with the land promise. So the court might award $27,500 as either reliance damages to restore him to where he would have been had the promise never been made. So that's important to remember, reliance damages, to restore him to where he would have been had the promise never been made, as if they never entered into the contract, or restitution for the benefit conferred, right? So so some courts, especially when the reliance is substantial and clear, as it is here, allow full expectation damages, despite that the statute of frauds, if necessary to avoid the injustice. So if it's necessary to avoid, Peter would then be entitled to the fair market value of the parcel, about $50,000, or as we know, he can't get specific performance because it's not available, for the reasons I stated before, such as, the land wasn't even identified. So an exam answer should recognize that the courts are split on whether promissory estoppel allow full or specific performance on a contract otherwise barred by the statute of frauds. So a moderate approach is that at a minimum, Peter recovers reliance damages, approximately the salary differential. He may argue for full expectation, like the land value, and some courts would grant that. So very quickly, just a summary of Peter's rights. As far as the employment's concerned, due to the statute of frauds, the multi-year employment term is likely unenforceable because, there's no mention of duration in there, in the writing. And the writing only supports only an indefinite at-will employment of $40,000 per year. As an at-will employee, Peter likely he likely has no contractual right to reinstatement or for future wages after termination. So only if the court bypasses the statute of frauds for the term would Peter recover approximately 3 months of lost wages for early termination. But I don't see that happening. And for the parcel of land, obviously there was a clear promise of land in exchange for working for 3 years, but there was no sufficient written memorandum. There was no writing. And the land contract is within the statute of frauds. So no traditional land part performance applies. Okay. He didn't move on the land. He didn't move on and make some statutory improvements. He didn't pay anything towards it. Not only that, but it wasn't identified. However, Peter substantially relied on the promise by accepting a lower salary and working for almost 3 years. So under promissory estoppel, Peter has a strong claim for at least reliance damages, likely measured by the salary differential, the $27,500, I think. And he may argue for full expectation, the value of the land, on the ground that injustice can only be avoided by enforcing the promise. If I was his lawyer, that's exactly what I'd be trying to do. At least get him $50,000, what she said it was worth, as opposed to his wages, those 3 months that he didn't get, or maybe both. $27,000 for the lost wages, not leading up to the 3 years, the $27,500, plus the $50,000 that he was expecting from that parcel of land that he never got. Right? Because he did have, even though the writing doesn't, but the problem is the statute of frauds wasn't satisfied, especially with the 1 year provision. Right? So bottom line, Peter's strongest claim is not continued employment, but to monetary relief tied to the promised parcel of land, most likely via promissory estoppel or restitution, with a plausible argument for either the value of the land or at a minimum the $27,500 salary differential he incurred in reliance on Della's promise. In a perfect world, he'd get both, but that's highly unlikely. So that's why it's really important, guys, when you enter into a contract. I can't tell you how many times even lawyers will enter into contracts without reading them. I've seen it happen time and time again with lawyers, and like somebody will hire a contractor to make an addition to their home. They'll just ignore the fact that the contract just leaves out all kinds of conditions, and then they cry and cry because the contractor didn't perform as he promised, and those conditions were never in the writing itself, and that's what you get. All right, guys, so I'm going to put it in the description, but we have 74 days from today. Today is December 11th. We're getting closer towards Christmas. Let's continue to do as many multiple choice questions as we can, as I said. What's really helpful is talking to other people, getting in small groups, talking to people about, what you're learning and things like that, outlining questions. If you have any questions, drop them in the comment section. If you have any constructive feedback, put those in the comment section. If you just want to tell me what a big bonehead idiot I am and I don't know what I'm talking about, put those in the comment section as well. We always appreciate those too. Share, like, and subscribe. Share with a friend who you know is in law school or who's studying for the bar, so that you can get them this information. I know it sounds monotone. I'm getting better, you guys. Give me some slack. Give me a thumbs up. Sons of yeah. All right, guys. Hope you guys enjoyed the show. That's it for me. I am super tired. It is late at night. It's about super late at night, and I'm ready for bed. Catch you guys tomorrow, where I will do a short video on a couple of rules. I was thinking about doing one for testimonial privilege and for marital communications privilege, explaining the difference between those. I think you guys will enjoy that. Anyway, keep a lookout for that. Catch you guys on the flip side. All right, suckers? All right, man. Good luck out there. And put a thumbs down like this if you think the California bar exam sucks nuts. Sucks big nuts. Put a big thumbs down. All right, guys. Looking forward to hearing from you. This is Legal Doc Guy. I'm out.